The HOA president tried to steal my lake access 3 times before she figured out I was a land surveyor. First time, she sent a lawyer with a threatening letter. Second time, she got the county to send me a violation notice. Third time, she sent an $85,000 excavator onto my property to build a dock she had no permission to build. That's when I sent the sheriff. My name's Derek Brennan. I'm 62, retired, and I've spent 35 years of my life determining exactly where one person's property ends and another person's begins. Which is why, when Brenda Kessler told me my lakefront beach was community property, I didn't argue with her. I just smiled, nodded, and started building a case. 6 months later, I was standing at the property line I'd surveyed myself 27 years ago, watching that 12-ton excavator grind to a halt. The operator climbed down, holding the court order I'd handed him. He read it twice, looked at the heavy chain I'd stretched across the access road, and climbed back into his cab. The diesel engine coughed, and he backed up the hill. 200 yards away, Brenda's face was the color of a stop sign. What she didn't know, what none of them knew, was that I had every email she'd ever sent, every trespassing incident on camera, every lie she'd told documented in triplicate. And I'd been waiting 6 months to use it all. But she didn't start out threatening to sue me. She started with a smile and a casserole. April 2024. I'd been living in my cabin for about 5 months when Brenda Kessler knocked on my door. She was wearing a pastel cardigan and holding a glass casserole dish with aluminum foil over the top. "Welcome to Clearwater Ridge," she said, flashing a smile that didn't quite reach her eyes. "I'm the HOA president. Just wanted to introduce myself." I invited her in. We sat on my porch overlooking the lake, and she told me how wonderful the community was, how everyone looked out for each other, how they had traditions that made this place special. Then she got to the point. "We've always had access to the lake through this property," she said, gesturing toward my beach. "The previous owner was very generous about letting families use it. I'm sure you'll want to continue that tradition." I didn't know much about HOA politics back then. I'd bought this land in 1998 as an investment, back when it was just empty acres and a dirt road. Paid $32,000 for 2.3 acres of prime lakefront. The lake itself, about 40 acres of spring-fed water, was technically private, surrounded by undeveloped parcels. Over the years, a developer bought up the surrounding land, carved it into lots, and built Clearwater Ridge, a gated community of 247 homes. Nice houses, quarter-acre lots, lake views. But here's the things about views. You can see the water, but you can't touch it, not legally, because every single one of those lots ended at the ridgeline, 50 to 80 feet above the waterline. My property was the only one with actual lake frontage, the only one with a deeded access road down to the water. I'd built that road myself in 1999, 12 feet wide, compacted gravel, proper drainage. I'd paid for every load of stone, and I'd surveyed every inch of it. When my wife died in 2018, I decided to finally build our dream cabin on that land. Took me a year. Moved in November 2023. I was looking forward to quiet mornings with coffee, watching the sun rise over the water, maybe doing some fishing. I wasn't looking for trouble. So when Brenda made her polite request, I said yes. "Keep it reasonable," I told her. "No big parties. Pick up your trash. Respect the property." She thanked me profusely. Said the whole community would be so grateful. What I didn't realize was that Brenda wasn't asking for a favor. She was confirming what she already believed, that my beach belonged to everyone. See, Brenda Kessler wasn't just the HOA president. She was also a real estate agent. Kessler Realty. She'd sold at least 60 of the homes in Clearwater Ridge over the past 10 years, and according to her sales materials, every single one of those homes came with community lake access. I found that out later. For the first 8 months, it worked fine. Families would come down on weekends, swim, paddle around in kayaks, leave by sunset. I'd wave from my porch, they'd wave back, no problems. Then, in December 2024, I took a walk down to the clubhouse to drop off my HOA dues. That's when I saw the architectural drawings taped to the window. Big color renderings, a 2-tier dock with a covered pavilion, composite decking, solar lights, kayak racks. At the bottom of the page, Clearwater Ridge Community Beach Project. Estimated cost $85,000. I stood there staring at that rendering for a full minute. The dock was drawn right onto my beach, my property. I walked back to my cabin, pulled out my survey, and traced the property line with my finger. No question about it. That dock was going to be built on land I owned, land I paid taxes on, land the HOA had zero legal claim to. The next morning I found a laminated notice staked into the sand. Notice of construction. The Clearwater Ridge HOA will begin Phase 1 construction of the Community Beach Amenity Project on January 15, 2025. This project is funded by a special assessment and approved by the Board of Directors. For questions, contact Brenda Kessler. I pulled out my phone and called her. She answered on the second ring. Hi, Derek, did you see the notice? Exciting, right? Brenda, I said, keeping my voice calm. Did anyone from the HOA ask my permission to build this dock? There was a pause. Then she laughed. A short, confused little laugh. Permission? Derek, we don't need permission. That's community property. No, I said. It's not. Well, she said, and I could hear the smile fading from her voice, we've been using it for years. Everyone knows it's part of the HOA. Show me the easement, I said. Another pause, longer this time. The what? The recorded easement. The legal document that gives the HOA access rights to my property. Show me that, and we're fine. I don't think we have anything like that, she said slowly. But it's always been, if you don't have an easement, Brenda, then you've been trespassing for years. And if you build that dock, I'll have it torn down and build to the HOA. The line went quiet. Then she said, in a voice I hadn't heard before, cold and clipped, we'll proceed as planned, Derek. This is for the good of the community. And she hung up. That night, I pulled every document I had, the original survey, the deed, the property tax records. I looked up the HOA covenants online. I read every word, and that's when I realized they had nothing. No easement, no recorded access rights, nothing. The HOA declaration, written in 2004, 6 years after I bought my land, mentioned community lake access in vague, aspirational language. But there was no legal description, no metes and bounds, no notarized agreement. It was all smoke. And Brenda Kessler, real estate agent and HOA president, had been selling homes based on a lie for a decade. I sat back in my chair and looked out at the dark water. Then I picked up the phone and called an old friend of my late wife, a real estate attorney named Ramona Vasquez. Ramona, I said when she answered, I need your help, and I think you're going to enjoy this. Ramona Vasquez had been practicing property law for 28 years. She'd handled everything from mineral rights disputes to boundary wars between neighbors who'd stopped speaking to each other in 1987. When I explained my situation, she was quiet for a moment. Then she said, Derek, I'm going to be honest with you. You have what we call a slam dunk case. But HOAs are vindictive. They have money, they have lawyers on retainer, and they don't like losing. If you fight this, prepare for it to get ugly. How ugly? I asked. Fines, liens, harassment. They'll make your life miserable for as long as they can. I looked out at the lake. My lake, the one I'd owned for 27 years. What do I need to do? Document everything, she said. Every interaction, every trespass, every threat. Get it in writing, get it on camera. Build a case so airtight they can't wiggle out of it. And then we hit them so hard they never try this again. I spent the next 3 days preparing. I ordered a trail camera from Amazon, the kind hunters use, motion activated with night vision and a timestamp. Mounted it on a tree at the entrance to the access road, angled so it captured everyone who came down. Then I printed property line markers, bright orange, and staked them every 20 feet along my boundary. I wanted there to be no confusion about where my land started. On December 18th, I sent an email to the entire HOA board. Subject line, Community Beach Project. Body, I do not consent to construction on my property. The beach area is private property as evidenced by the attached survey and deed. Any entry onto this property without my explicit written permission constitutes trespassing under state law. I expect all construction plans to be halted immediately. I attached my survey, my deed, and the relevant property tax records showing I'd been paying 100% of the taxes on that parcel since 1998. Sent it certified, return receipt requested. Brenda's reply came back in 47 minutes. Derek, you're being selfish. 247 families depend on that lake access. It's been part of this community for nearly 2 decades. We've already awarded the construction contract and collected the special assessment from homeowners. We will proceed as planned on January 15th. If you have concerns, you're welcome to attend the next board meeting. Selfish. That word stuck with me. I'd bought this land when it was nothing but trees and mud. I'd paid for the road. I'd paid taxes on every square inch for 27 years. And now I was selfish for not letting them build an $85,000 dock on it without asking. I forwarded Brenda's email to Ramona. She called me 10 minutes later. Derek, this is gold. She just admitted in writing that they're proceeding without your permission. That's knowing and willful trespass. What's my next move? We file for a temporary restraining order, stop the construction before it starts, and in the meantime, you keep that camera rolling. I want footage of every single person who steps foot on your property between now and January 15th. I hung up and looked at the calendar. December 18th. I had 28 days until the excavator showed up. 28 days to build a case that would end this before it started. I opened my laptop and created a spreadsheet. Date, time, description, evidence. Then I waited. I didn't have to wait long. The trail camera started recording on December 20th. By Christmas Eve, it had captured 19 separate incidents. Families walking down to the beach, unaware they were on private property. Kids splashing in the shallows, a couple having a picnic on my dock. I didn't confront anyone. I just logged every entry into my spreadsheet and saved the footage. Evidence. On December 27th, I ran into my neighbor Paulette at the mailbox. Paulette Chen, mid-50s, worked from home doing something with medical billing. She'd always been friendly, waved when she saw me. This time, she looked around like she was checking for surveillance, then leaned in close. "Derek, I heard about the docs situation." "Yeah," I said. "It's a mess." "Look, I don't want to get involved, but," she hesitated. "Brenda pushed that contract through really fast. Like, suspiciously fast. The board didn't even get competitive bids. She just said her friend knew a contractor who could do it cheap." "Her friend?" "Stephanie Marsh. Her husband owns a construction company. I think it's called Shields Construction, something like that. They do a lot of county work." I filed that away. Shields Construction, county work. "Thanks for telling me, Paulette." She glanced over her shoulder. "I didn't tell you anything, okay? Brenda denied my fence variance last year because I didn't follow proper procedure. She's not someone you want mad at you." "I understand." I called Ramona that night. The HOA awarded an $85,000 contract without competitive bidding. "Does that matter?" "Depends," she said. "If there's a conflict of interest or kickback, it could invalidate the contract, but that's a separate issue. Right now, we focus on the trespass. One thing at a time." "Got it." "Derek, I need to warn you about something. If this goes to court, they're going to try to claim prescriptive easement. That's when someone uses your property openly for so long that they gain a legal right to keep using it." "How long is so long?" "In the state, 20 years. Continuous, open, and adverse use. The HOA's only existed since 2004. That's 18 years. "Exactly. And more importantly, you gave them permission. That negates the adverse requirement, but they'll still argue it. Be prepared." I looked at my trail camera footage. 19 incidents in 7 days. If this kept up, by January 15th, I'd have over 100 documented trespasses. Let them argue prescriptive easement. I had timestamps. January 15th arrived cold and clear. I woke up at 6, made coffee, and walked down to the access road. The chain was already in my truck bed, 15 feet of heavy-gauge steel, the kind they use to secure construction sites. The padlock was Navy grade, the same kind we used on equipment in the service. Bolt cutters wouldn't touch it. At 6:45, I heard the rumble of diesel engines coming up the main road. I called Deputy Frank Hollister. Frank and I had met a few times at the hardware store, talked about fishing. He was former Marine Corps, late 50s, the kind of cop who actually read the law instead of just guessing at it. "Frank, it's Derek Brennan out at Clearwater Ridge. I've got a construction crew about to trespass on my property. I have a restraining order from the court. Can you meet me here?" "On my way." The excavator came around the bend at 7:03. Big yellow cat, treads clanking, operator in the cab scrolling on his phone. Behind him, a pickup truck with Shields Construction LLC on the door, 2 workers in the bed. The excavator stopped at the property line where my orange markers were staked. The operator climbed down, lit a cigarette, and looked around like he was trying to figure out if he was in the right place. I walked over. "Morning," I said. "Can I help you?" "Yeah, we're supposed to start a dock project down there." He pointed toward the beach. "Do you have permission from the property owner?" He looked confused. "The HOA hired us." "I'm the property owner," I said, "and I didn't give permission." His face changed. "Look, man, I don't want trouble. I just go where my boss tells me." "I understand. Here." I handed him 3 documents. "This is a certified survey showing I own this property. This is a copy of my deed. And this is a temporary restraining order from the county court, issued yesterday, prohibiting any construction on this parcel without my written consent. If you proceed, you're in violation of a court order." He took the papers, read the first page of the TRO, and his shoulders sagged. He pulled out his phone and called someone. I could hear the conversation. "Yeah, it's me. We got a problem. The landowner's here with a court order. No, he's serious. There's a sheriff's deputy pulling up right now. I don't know, man. You figure it out. I'm not catching a contempt charge for a dock. Frank's cruiser rolled to a stop behind the excavator. He got out, adjusted his belt, and walked over. Gentlemen, what's the situation? The operator showed him the TRO. Frank read it, nodded, and looked at the crew. You're free to leave. If you proceed onto this property, you'll be trespassing and I'll have to arrest you. The operator didn't need to be told twice. He climbed into the cab, fired up the engine, and backed the excavator up the hill. The pickup followed. The whole thing took 9 minutes. Then Brenda's Mercedes came screeching down the road. She got out before the car even stopped rolling, her face red, her voice shaking. What the hell do you think you're doing? Protecting my property, I said. You can't do this. That dock is funded. We have 247 families who... Show me the easement, Brenda. She stopped, blinked. What? Show me the recorded easement that gives the HOA legal access to my property. We don't need an easement. We've been using... That's called trespassing, Frank said quietly. Brenda turned to him. Deputy, this is a civil matter. Ma'am, he has a restraining order. If you proceed with construction, it's contempt of court. That's criminal. I handed her a copy of the TRO. You're served. There's a hearing in 14 days. Bring your lawyer. Her hand trembled as she took the paper. Then she turned and walked back to her car without another word. After she left, I pulled the chain out of my truck, stretched it across the access road, and locked it. The padlock made a satisfying click. I mounted a sign. Private road, owner access only. Violators will be prosecuted. Frank watched me work. You know this is just the beginning, right? I know. They're going to make your life hell. Let them try. I took a photo of the locked chain with my phone. Timestamp January 15th, 2025, 7:34 a.m. Then I walked back to my cabin and added it to my evidence folder. The padlock stayed locked for exactly 4 hours and 16 minutes. Then Brenda tried something creative. 4 hours and 16 minutes after I locked the chain, my trail camera caught 3 people walking down the access road. Brenda Kessler, a man I didn't recognize, about 40, wearing a suit, and another board member, Janet Somebody, who I'd seen at the clubhouse. They stopped at the chain. Brenda pointed at the padlock. The man in the suit pulled something out of his jacket. Bolt cutters. The camera captured everything. The audio picked up Brenda saying, "Just cut it. He can't stop all of us." The man positioned the bolt cutters on the lock. Then he squeezed. The handles bent. The lock didn't. He tried again, putting his full weight into it. Nothing. "What the hell kind of lock is this?" he muttered. "Military grade," I said from behind them. All 3 of them jumped. I'd walked down through the woods, staying off the road. "That's a Navy pack lock. Hardened steel shackle. You'd need an angle grinder to get through it. Or, my permission." Brenda's face went white, then red. You can't just lock us out." "I can, actually. It's my property." "We'll sue you." "Go ahead. I'll see you at the hearing in 12 days. The man in the suit stepped forward. "Mr. Brennan, I'm Howard Wallace from Wallace and Finch LLP. We represent the HOA. This behavior is..." "I know who you are, Mr. Wallace. You can send any correspondence to my attorney, Ramona Vasquez." I handed him her card. "Now get off my property before I call the sheriff again." They left. But I kept the camera footage, added it to the spreadsheet. January 15th, 2025, 11:50 a.m. Attempted destruction of property. 3 witnesses, audio and video evidence. The HOA held an emergency board meeting 2 days later. I found out because they didn't follow proper procedure. No 48-hour public notice, which violated the state's Open Meetings Act. A neighbor texted me a photo of the agenda. Emergency session. Legal action against Derek Brennan. The board voted 5-2 to levy a $500 per month fine against me for blocking community access to common areas. They also voted to authorize Wallace and Finch to file a counter-injunction. And they sent a mass email to all 247 homeowners. Subject: Important community update. Body: Due to the actions of one selfish resident, the community beach project has been delayed. Derek Brennan has illegally blocked access to our lake, hurting property values and denying families the amenities they paid for. The board is taking legal action to protect your rights. I forwarded it to Ramona. She called me 30 seconds later, laughing. "Derek, they just slandered you in writing to 247 witnesses. This is malpractice-level stupidity." Is that good for us? It's Christmas morning for a litigation attorney. 2 days later, an 8-page demand letter arrived from Wallace and Finch. Certified mail, signed receipt. The letter claimed the HOA had a prescriptive easement due to open, notorious, and continuous use since 2004. It demanded I remove the chain, cease all interference with HOA activities, and pay damages of $250,000 for harm to property values. It was CC'd to every homeowner in Clearwater Ridge via email. My phone started ringing that night. Some calls were supportive. Most weren't. One man, voice shaking with rage, told me I was ruining his property investment. A woman said I should be ashamed for keeping kids away from the lake. Someone left a voicemail that just said, "I hope your house burns down." I saved every message, added them to the evidence file. Harassment, threats, December 19th through January 23rd. Then the vandalism started. January 25th, someone keyed my truck in the driveway. Long, deep scratches down both sides. I filed a police report. January 27th, my mailbox was ripped out of the ground and thrown into the ditch. Filed another report. January 30th, someone dumped a trash bag full of rotting food on my driveway. The smell was incredible. I took photos, filed a third report, and hosed it off. The next door posts were even worse. Anonymous accounts with names like Concerned Resident and Community First posting things like, "Selfish new guy blocking our lake. Disgusting. Who does Derek Brennan think he is? If you see him around town, let him know what you think of him." I stopped going to the grocery store in town, started driving 20 minutes to the next county over. Ramona sent a response to Wallace and Finch on February 3rd. 3 pages, surgical precision. She pointed out that prescriptive easements in this state required 20 years of adverse use. The HOA had only existed for 18. She noted that I had given permission for prior use, which negated the adverse requirement. She attached documentation showing I'd paid property taxes on the disputed parcel since 1998, while the HOA had paid $0, and she ended with a warning. Any further harassment of Mr. Brennan, including but not limited to fines, liens, or disparagement, will result in counterclaims for intentional infliction of emotional distress, slander, and abusive process. We await your substantive legal response. She also requested the HOA's liability insurance information. That's lawyer speak for, "I'm about to sue you, and I want to know who's paying." The hate mail kept coming, but so did something else. February 8th. My trail camera caught a woman in yoga pants trying to sneak around the chain by walking through the woods. She made it about 15 feet before getting tangled in blackberry brambles. Spent 5 minutes extracting herself, cursing the whole time. February 10th. 2 teenagers tried to wade into the lake from the far side of my property, thinking they could avoid the road. One of them slipped on the rocks and went in fully clothed. His friend had to pull him out. February 14th. A man in his 60s, wearing dress shoes and khakis, attempted to climb over a fallen log to reach the beach. He got stuck halfway over, legs dangling, and had to call his wife to come help him down. I watched these videos with a cup of coffee, shaking my head. Entitled Suburbanites Attempting Wilderness Navigation was not the retirement entertainment I'd expected, but I wasn't complaining. Every failed attempt was another timestamp in my evidence file. Another data point showing the HOA and its members knew they didn't have legal access and were trying to take it anyway. But Brenda still had one card she hadn't played yet, and it was a card that could have actually worked if she hadn't gotten greedy. February 12th, 2025. I was sitting on my porch when the mail truck pulled up. The carrier handed me a certified letter from the county planning department. I signed for it, went inside, and opened it. Notice of violation. It has come to our attention that you have installed an unpermitted barrier across a public right-of-way on parcel 447B, Block 12, Clearwater Ridge Development. This barrier must be removed within 10 business days, or you will face fines of $1,000 per day. The access road in question is designated as public right-of-way per the 1987 subdivision plat. Contact our office immediately to schedule removal. I read it 3 times, then I pulled out my records. The 1987 plat showed nothing but empty forest, no roads, no subdivision, no development, because in 1987 none of that existed yet. I built the access road in 1999, 12 years later. I paid for every cubic yard of gravel. I still had the receipts. I called the planning department. "This is Derek Brennan. I just received a violation notice about a road on my property. Can you tell me who filed the complaint?" The clerk put me on hold for 2 minutes. Then, the complaint was filed by Brenda Kessler on behalf of the Clearwater Ridge HOA. It was flagged for priority review by Commissioner Marcus Shields. Marcus Shields, County Commissioner. I didn't know the name, but I knew what priority review meant. Someone with juice had made a phone call. "Can you send me a copy of the 1987 plat you're referencing?" It should be attached to the notice. It's not. Oh, well, I can email it to you. She did. I opened the file. The plat showed the subdivision boundaries, lot lines, easements for utilities. No access road to the lake, because the lake wasn't part of the subdivision. It was surrounded by private parcels, including mine. I called Ramona. They're lying. The county's claiming my road is public, but their own records show it's not. Who signed the violation notice? An inspector named Gerald Fouts, but it was flagged by Commissioner Shields. Shields, she repeated. Okay, let me make some calls. While Ramona worked her end, I filed a Freedom of Information Act request with the county. I wanted every document related to my violation notice, every email, every memo, every communication between Brenda Kessler and anyone in the planning department. FOIA requests take time, but I wasn't in a hurry. I had a court date coming up. Let them try to justify this in front of a judge. Then, on February 18th, I got a call from a number I didn't recognize. Mr. Brennan? This is Curtis Lehman. I'm a reporter with the Valley Observer. I cover local government and development. I saw your name on some court filings and wanted to ask you a few questions. I almost hung up, but something made me pause. What kind of questions? I've been investigating Commissioner Shields for about 6 months. Ethics violations, conflicts of interest, that sort of thing. Your case popped up on my radar because Shields personally expedited a violation notice against you. That's unusual. Mind if I ask what's going on? I gave him the short version. My property, the HOA's dock project, the trespassing, the violation notice. Curtis was quiet for a moment. Then he said, Mr. Brennan, can we meet in person? I think we can help each other. We met at a coffee shop in the next town over. Curtis was 47, wire-rimmed glasses, the kind of guy who looked like he'd been a journalist his whole life. He brought a folder 3 inches thick. Okay, he said, spreading documents across the table. Here's what I know about Marcus Shields. He's been county commissioner for 8 years. He's up for re-election this year. And he has a very interesting business arrangement with his nephew. He slid a business registration across the table. Shields Construction LLC, registered owner Brian Shields, Marcus Shields' nephew. They do a lot of county work, paving, drainage, maintenance contracts, and last year they started doing private work for HOAs. I stared at the name. Shields Construction, the company Brenda hired for the dock. Curtis nodded. Yeah, I pulled the bids for your HOA's dock project. 3 companies submitted proposals. The other 2 came in at $52,000 and $58,000. Shields Construction bid $85,000. They were awarded the contract anyway. That's a $30,000 difference. Correct. And here's the fun part. He pulled out campaign finance records. In the last 2 years, HOA board members from Clearwater Ridge have donated $8,500 to Marcus Shields' re-election campaign. Brenda Kessler personally gave $2,500. I sat back. So she donates to his campaign, he fast-tracks permits and violations for her, and his nephew gets inflated contracts. That's what it looks like. But I need proof. I need documents, emails, something that shows coordination. Do you have anything? I thought about my FOIA request. I will, in about 2 weeks. Curtis published a preliminary article on February 20th. The headline, HOA Influence Peddling When Community Boards Play Politics. It wasn't about me specifically. It was a broader piece about how HOAs in the county were cozying up to local officials, donating to campaigns, and getting favorable treatment in return, but it mentioned Clearwater Ridge by name. It mentioned Shields Construction. And it mentioned an unnamed property owner fighting back against an HOA that allegedly misrepresented access rights to homeowners. The article got traction. Local Reddit picked it up. 47,000 upvotes on the HOA subreddit. People started sharing their own stories in the comments. The local TV station called me for an interview. I almost said no, but then I thought about Brenda's email blast calling me selfish, about the hate mail, about the vandalism. Screw it, I said yes. The interview aired on February 24th. The reporter asked me point blank, "Is it true you're blocking 247 families from accessing the lake?" "No," I said, looking directly at the camera. "I'm blocking an HOA from building on my private property without permission. They've been trespassing for 18 years and calling it tradition. There's a legal term for that. It's called theft. But families have been using that beach with my permission. Permission I can revoke at any time. That's what property rights mean. The HOA says you're selfish. The HOA sold homes by promising lake access they didn't legally have. That's fraud. I'm not the villain here. I'm the guy who actually owns the land." The clip went viral. 180,000 views in 3 days. The comments were overwhelmingly supportive. Good for him. HOAs are parasites. Why would anyone buy a home without checking the title? But in Clearwater Ridge, the reaction was different. The HOA held another emergency meeting on February 27th. 3 more board members resigned. Janet somebody quit via email saying she didn't sign up for this. Another guy, Tom something, posted on Nextdoor, "I was told this was routine. I didn't know we were trespassing. I'm out." That left Brenda with 2 loyalists and a hemorrhaging board. But she didn't back down. Instead, she doubled down. She hired a PR firm out of the city, sent glossy mailers to every home in the development. "Don't let one outsider destroy our community. Support your HOA." She organized a Save Our Lake rally in the clubhouse parking lot. 30 people showed up. Most of them looked confused. One woman held a sign that said, "Kids need water." I watched from my porch through binoculars, shaking my head. Brenda was on a microphone, voice crackling through a cheap speaker, talking about community values and tradition. But I could see it in the crowd's faces. They weren't buying it anymore. Because the story had changed. It wasn't Mean Guy Blocks Lake anymore. It was HOA caught lying about property rights. And once that narrative shifted, Brenda couldn't spin it back. She made a critical mistake. She thought public opinion would destroy me. Instead, it was about to destroy her. Curtis Lehman published his full investigation on March 7th. The headline, "The Lake Access Land Grab, How One HOA Built an Empire on Someone Else's Property." It was 3,000 words, meticulously sourced, and it tore the HOA apart. The article detailed everything. My 1998 property purchase, 6 years before the HOA even existed. The lack of any recorded easement on my title. The HOA's sales materials promising lake access without securing legal rights. The $85,000 dock contract awarded to Commissioner Shields' nephew, $30,000 over competitive bids. The campaign donations from Brenda and other board members. And the county violation notice expedited by Shields, based on a plat that didn't show the road in question. Curtis included copies of documents, my survey, the HOA covenants with the vague lake access language, the construction bids, the campaign finance reports. He even got a statement from Wallace and Finch, the HOA's attorney, which boiled down to no comment. The comment section exploded. Over 900 comments in the first 2 days. "This is why I'll never live in an HOA. Brenda Kessler should be in jail. How is this not fraud?" A Reddit thread titled "Justice for the Lake Guy" hit the front page of several subreddits. Someone made a meme of Brenda's face photoshopped onto a pirate, captioned, "But it's community property." It got 62,000 shares. Back in Clearwater Ridge, the mood shifted hard. Nextdoor went from pro-HOA to anti-HOA overnight. People started asking questions. Wait, we don't actually have legal access to the lake? Did Brenda lie to us when we bought our homes? Why did we pay a special assessment for a dock we can't legally build? A petition started circulating demanding Brenda's resignation. Within a week, 112 people signed it. Almost half the community. My mailbox, which had been full of hate mail a month ago, started getting apology letters. One couple wrote, "We're sorry we believed the board. We didn't know the full story. Thank you for standing up for property rights." An older man stopped me at the gas station. "I voted for that special assessment. I feel like an idiot. They lied to all of us." I didn't gloat. I just nodded and said, "Make sure you show up to the next board meeting." Then the County Ethics Board opened an investigation into Commissioner Shields. The complaint cited Curtis's article and requested a formal review of the campaign donations and the expedited violation notice. Shields issued a statement denying any wrongdoing, but 2 weeks later he recused himself from all HOA-related matters. The violation notice against me was quietly rescinded. No explanation, just a one-sentence letter. Upon further review, the access road in question is determined to be private property. Case closed. I framed that letter and hung it in my office. But the real bombshell came from an unexpected source. A title insurance investigator named Yolanda Mercer. Yolanda Mercer worked for Consolidated Title, one of the largest title insurance companies in the state. Her job was to investigate irregularities, flag potential fraud, and make sure the company wasn't on the hook for bad claims. On March 10th, she sent a letter to the Clearwater Ridge HOA board, CC'd to every homeowner with a subject line that made my day: title defect notice, lake access easement claims. The letter was professional, clinical, and devastating. Yolanda had reviewed the title records for all 247 properties in Clearwater Ridge. Her findings: 0 recorded easements for lake access on any parcel. The HOA declaration mentioned lake access in aspirational language. but contained no metes and bounds legal description, no recorded instrument, and no evidence of compensation paid to any property owner. Multiple homes had been sold with marketing materials explicitly promising community lake access as an amenity, which constituted a materially misleading representation. Homeowners who purchased properties based on these representations may have claims against the HOA, the developer, or the real estate agents involved for fraudulent inducement. Her conclusion? Consolidated Title cannot insure any easement claim related to lake access in Clearwater Ridge. Any such claim would be denied. In other words, if you bought your house thinking you had lake access, your title insurance won't cover it. Because the access never existed, and if you want to sue someone about it, sue the HOA. The fallout was immediate. 18 homeowners, including 3 board members' families, retained attorneys and threatened to sue the HOA board personally for breach of fiduciary duty. The HOA's insurance carrier sent a denial letter stating that coverage for wrongful taking or conversion of non-HOA property was explicitly excluded under the policy, which meant the HOA's $340,000 in reserve funds were now exposed. Wallace and Finch, the law firm representing the HOA, withdrew as counsel due to conflict of interest. Turns out, representing a board that might get sued by its own members is a legal minefield. The HOA scrambled to hire a new attorney at $450 an hour. Then Brenda made one last desperate play. She called an emergency homeowner meeting on March 16th to propose a special assessment of $2,000 per household to fund the legal defense. $2,000 per household to fight me. The clubhouse was packed, standing room only, and it did not go the way Brenda expected. I didn't attend, but Paulette recorded the whole thing on her phone and sent it to me later. Brenda stood at the front, visibly shaken, trying to rally support. If we don't fight this, Derek Brennan wins. He'll control access to the lake forever. Our property values will... A man in the back stood up. You told us we had lake access when we bought our homes. We do have access. We just need to formalize... You lied, a woman shouted. You sold us houses with an amenity you didn't own? Another voice. Why should we pay $2,000 to fix your screw-up? This isn't my screw-up. This is... You're the president. You're the one who hired the contractor. You're the one who pushed this through without checking if we had the legal right. The meeting devolved into shouting. Brenda tried to call for order. No one listened. Finally, 89 homeowners signed a letter on the spot addressed to the board. We were misled about lake access. We will not pay additional assessments to fund litigation. Settle with Mr. Brennan immediately, or we will pursue legal action against the board. Brenda's face went pale. One of her 2 remaining board members stood up and said, I resign, effective immediately. The other one followed. Me too. I'm not going down with this ship. Brenda was left standing alone at the front of the room, holding a gavel, with no board and no support. 3 days later, Ramona received a call from the HOA's new attorney, a guy named Peter Drummond. Miss Vasquez, my client is interested in discussing settlement. I'm listening. The board is prepared to acknowledge that no easement exists, record a notice on all property deeds to that effect, and issue a public apology. They're also willing to discuss reasonable compensation. How reasonable? $50,000. Ramona laughed. Mr. Drummond, your client trespassed on my client's property for 18 years, attempted to build an $85,000 structure without permission, slandered him in writing to 247 people, and subjected him to harassment and vandalism. $50,000 doesn't cover his attorney fees. What's your number? $150,000, plus all the terms you mentioned, plus Brenda Kessler's resignation, and in exchange, Mr. Brennan will grant the HOA a revocable license for limited lake access. Take it or leave it. I'll discuss it with what's left of the board. 2 days later, they agreed to everything except Brenda's resignation. She quit on her own the next morning, April 12th. The hearing I'd been building towards since January. The county courthouse was a limestone building with Roman columns, the kind of place that made you feel like the law still meant something. I arrived at 8:30 for a 9 o'clock hearing. The courtroom was already filling up. I counted at least 40 people in the gallery. Most of them were Clearwater Ridge residents. Some looked curious, some looked angry. Curtis Lehman was in the press section with a notepad. Paulette gave me a small wave from the back row. Ramona met me outside the courtroom doors. She was wearing a navy suit and carrying a leather briefcase that looked like it had seen a few wars. You ready? She asked. I've been ready since December. Good. Remember, let me do the talking. If the judge asks you a direct question, answer it calmly and stick to facts. Don't editorialize. Got it. And Derek, we're going to win this. Judge Andrea Thornhill took the bench at 9:03. She was in her early 60s, silver hair pulled back, reading glasses on a chain around her neck. She had a reputation for no-nonsense rulings and zero patience for bullshit. "Good morning," she said, settling into her chair. "This is a preliminary injunction hearing on the motion filed by Derek Brennan and the HOA's counterclaims. Let's get started. Counsel, state your appearances." Ramona stood. "Ramona Vasquez for petitioner Derek Brennan, Your Honor." On the other side of the aisle, a woman in her 40s stood. "Melissa Dupree for respondent Clearwater Ridge Homeowners Association, Your Honor." "Miss Dupree, you're up first. Tell me why the court should deny Mr. Brennan's injunction." Melissa Dupree was polished, confident, and clearly expensive. She approached the podium with a folder full of notes. "Thank you, Your Honor. The HOA's position is straightforward. For 18 years, the residents of Clearwater Ridge have enjoyed access to the lake through the property now owned by Mr. Brennan. This access was open, continuous, and uninterrupted. Families have swum there, held gatherings there, and relied on that access as a fundamental amenity of the community." She clicked a remote, and photos appeared on the courtroom screen. Families on the beach, kids splashing in the water, people sitting on my dock. "These are not trespassers, Your Honor. These are neighbors exercising what they reasonably believe to be a community right. The prior property owner permitted this use for years. When Mr. Brennan purchased the property, that implied permission continued. To now suddenly block access harms 247 families and undermines the reasonable expectations upon which they purchased their homes." She paused for effect. "The HOA acknowledges that no formal easement was recorded. But under the doctrine of prescriptive easement, long-term open use can create a legal right. While the statutory period is typically 20 years, equity may justify a shorter period when the use has been so well established and relied upon. The HOA asks this court to recognize that equity and allow access to continue while the parties negotiate a formal agreement." She played a video. Kids crying, a little girl, maybe 7, saying, "Why can't we go to the beach anymore?" A dad with his hand on her shoulder, looking into the camera. "Our kids don't understand. This has always been part of our neighborhood." Melissa sat down. It was a good performance. Emotional, sympathetic, designed to make me look like the Grinch who stole summer. Judge Thornhill made a note. Then she looked at Ramona. "Miss Vasquez." Ramona stood, walked to the podium, and didn't open a single piece of paper. "Your Honor, this case is not complicated. It's Property Law 101. Mr. Brennan owns the land. The HOA does not. There is no easement, recorded or otherwise. Everything else is noise." She clicked her own remote. My survey appeared on the screen, clean and official, with a surveyor's seal in the corner. "This is the certified survey of Mr. Brennan's property, conducted in 1998 when he purchased it. The boundary clearly includes the beach area and the access road. This property was purchased 6 years before the HOA was incorporated. 6 years. The HOA didn't exist when Mr. Brennan bought this land." Next slide, my deed with the legal description highlighted. "This is the recorded deed. It has been on file with the county since 1998. No easements, no encumbrances, clear title." Next slide, property tax records. Mr. Brennan has paid 100% of the property taxes on this parcel for 27 years. The HOA has paid 0 because it's not their property. Judge Thornhill leaned forward slightly. Miss Dupree raised the issue of prescriptive easement. "What's your response?" "Two responses, Your Honor. First, this state requires 20 years of continuous open and adverse use for a prescriptive easement to vest. The HOA has existed for only 18 years. They don't meet the statutory period. And second, the use wasn't adverse. Mr. Brennan's predecessor gave permission for occasional use. Permission negates the adverse requirement. You can't trespass with permission and then later claim you earned the right to keep trespassing." The judge nodded slowly. "Continue." Ramona pulled up another document. "This is the HOA declaration, recorded in 2004. Page 14, Section 7, mentions community lake access, but there's no legal description, no metes and bounds, no recorded easement, just vague aspirational language. And here," she highlighted a sentence, "Section 12, subsection C, states, access to non-HOA properties requires written consent of the affected landowner. Their own covenants require my client's permission." She let that hang in the air. Then she played her own video. Trail camera footage, time-stamped, Brenda and 2 people with bolt cutters trying to cut the lock. Audio. "Just cut it. He can't stop all of us." Melissa Dupree's face went white. Ramona didn't even look at her. "Your Honor, This was recorded 4 hours after Mr. Brennan lawfully installed a lock on his private property. The HOA president, knowingly and willfully, attempted to destroy that lock to gain unauthorized access. That is not the behavior of someone who believes they have a legal right. That's the behavior of someone who knows they're trespassing and doesn't care. She clicked to the next slide. An email. Brenda Kessler to the board, dated February 3rd, 2024. Subject, easement issue. Body. We need to figure out the easement situation before Brennan finds out we don't have one. Ramona looked up at the judge. They knew, Your Honor. They knew they didn't have legal access and they proceeded anyway. Judge Thornhill turned to Melissa. Counselor, did you know about this email? Melissa stood slowly. I was not aware of that specific communication, Your Honor. So your client didn't disclose it? We're still in discovery. This email is dated over a year ago. It's directly relevant to your prescriptive easement argument. If they knew they didn't have an easement, the use couldn't have been open and notorious in good faith. Melissa had no response. The judge turned back to Ramona. Anything else? One more thing, Your Honor. Ramona approached the bench and handed a document to the clerk. This is an affidavit from the prior property owner, located and interviewed by our office. He states, and I quote, I allowed occasional recreational use of the beach as a courtesy to neighbors. I made it clear to the HOA that this was not a permanent arrangement and did not convey any property rights. When I sold the property in 2019, I informed the buyer that no easement existed. She stepped back. Your Honor, Mr. Brennan is not the villain here. He's a retired surveyor who bought land, paid for it, improved it, and has been subjected to months of harassment for asserting his legal rights. The HOA sold homes promising amenities they didn't own. That's not Mr. Brennan's fault. That's fraud. And it's not this court's job to fix the HOA's fraud by taking my client's property. Judge Thornhill removed her glasses and rubbed her eyes. Then she looked at Melissa. Miss Dupree, I've reviewed the filings. I've heard your arguments. Do you have any legal basis, any case law, any statute, anything that supports granting an easement under these facts? Melissa stood. Your Honor, we believe that equity doesn't override property law, Counselor. What's your legal basis? We would argue that the reliance interest of 247 families is a policy argument, not a legal one. Do you have a legal basis? Melissa hesitated. Not at this time, Your Honor. Then we're done here. Judge Thornhill put her glasses back on and looked at her notes. Then she looked up. Mr. Brennan owns the property. That's not in dispute. There is no recorded easement. That's not in dispute. The HOA has not met the requirements for a prescriptive easement, both because of the time period and because prior use was permissive, not adverse. The HOA's own covenants require written consent for access to non-HOA properties, which Mr. Brennan has not provided. The evidence shows that the HOA knew it lacked legal access and proceeded with construction plans anyway, culminating in attempted destruction of Mr. Brennan's property. This is one of the clearer property disputes I've seen. She picked up her gavel. I'm granting Mr. Brennan's motion for preliminary injunction. The Clearwater Ridge HOA, its board members, and all residents are permanently enjoined from entering Mr. Brennan's property without his express written consent. Any violation of this order will be considered contempt of court. Further, I'm awarding Mr. Brennan attorney's fees and costs in the amount of, she glanced at a document, $37,000, payable within 30 days. If the HOA wishes to pursue an easement through negotiation or eminent domain, they're free to do so. But based on this record, I don't see a path forward. We're adjourned. The gavel came down, one sharp crack. Brenda, sitting in the front row, put her face in her hands. Several homeowners in the gallery started whispering. A few got up and left immediately. Paulette was grinning from the back row. Curtis was scribbling notes furiously. Ramona shook my hand. Textbook win, she said quietly. As we walked out, an older woman approached me in the hallway. Mr. Brennan, I owe you an apology. I signed that petition against you back in January. I didn't know the whole story. Thank you for standing up for what's right. I nodded. Thank you for saying that. Two other people stopped me on the courthouse steps to apologize. One man said, Brenda lied to all of us. I'm glad you won. I didn't gloat. I didn't celebrate. I just got in my truck and drove home. Because winning in court was only half the battle. The real question was, what do you do with power once you've got it? Brenda Kessler resigned as HOA president on April 20th. No ceremony, no farewell speech. Just a one-sentence email to the membership. Effective immediately, I am stepping down from the board. The special election happened 2 weeks later. Paulette Chen ran unopposed and won. Her first act as president was to settle my lawsuit, $150,000, a public apology posted on the HOA website and mailed to every household, and a recorded notice on all 247 property deeds stating clearly, no lake access easement exists for this property. Commissioner Marcus Shields was censured by the County Ethics Board in May. He didn't run for re-election. His nephew's company, Shields Construction, was quietly removed from the county's approved contractor list. Wallace and Finch, the law firm that sent me the threatening letter, received a reprimand from the State Bar Association for failure to adequately investigate claims before asserting them in legal correspondence. It didn't hurt them much, but it was something. I could have walked away at that point, taken the money, kept the chain locked, and lived out my retirement in peace. And for a few weeks I considered it. But then I started thinking about what Ramona had said back in December. When you win, what are you going to do with it? So I drafted something I called the Clearwater Lake Community Access Agreement. It wasn't an easement. It was a revocable license, meaning I kept full control and I could terminate at any time if people didn't follow the rules. The terms were simple. Maximum 30 families per day, managed through an online reservation system. Access hours, 9 a.m. to 7 p.m., Memorial Day through Labor Day. No structures, no fires, no alcohol. Pack in, pack out, leave no trace. Every family had to complete 1 hour of volunteer lake cleanup per season. If you didn't volunteer, you didn't get access the next year. And a $25 annual maintenance fee per household, which covered gravel road upkeep, a portable toilet, and liability insurance. The license was revocable if anyone violated the rules. 1 strike, you're out for the season. 2 strikes, you're banned permanently. I presented it to Paulette and the new board in June. They read it, looked at each other, and Paulette said, "This is more than fair, Derek. Thank you." I never wanted to block access, I told them. I wanted respect. Now we have both. But I didn't stop there. The $150,000 settlement was more money than I needed, so I put it to work. First, I established the Clearwater Conservation Fund with $80,000. It was a small nonprofit registered with the state focused on protecting the lake from future development. We partnered with the State Department of Natural Resources to install fish habitats, plant native vegetation along the shoreline, and conduct quarterly water quality testing. The goal was to make sure that lake stayed pristine for the next 100 years. Second, I endowed a $40,000 scholarship called the Surveyor's Scholarship, $2,000 annually to a local high school student pursuing land surveying, civil engineering, or a related field. The first recipient was Maya Chen, Paulette's daughter, who was headed to State University in the fall to study environmental engineering. When I handed her the check at the awards ceremony, she teared up. "Thank you, Mr. Brennan. This means everything." I shook her hand. "Your mom stood up when it mattered. This is for both of you." Third, I set aside $30,000 for something I called the Good Neighbor Legal Defense Fund. It provided free consultations with Ramona for any homeowner in the county dealing with HOA overreach, not just Clearwater Ridge, anyone. Because I'd learned that Brenda wasn't unique. There were a dozen Brendas and a dozen HOAs, all doing the same thing, leveraging power they didn't legally have, hoping no one would push back. Now, someone could. On June 15th, we held the first annual Lake Restoration Day. 120 volunteers showed up. We planted 40 native trees, installed 15 bat boxes, cleaned 2 tons of trash and debris from the shoreline, and built a small nature trail on the far side of the lake. Families I'd fought with in court were working side by side with me, hauling mulch and planting shrubs. Even some of the people who'd sent me hate mail showed up to apologize in person. One guy, mid-40s, pulled me aside. "I wrote some awful things about you. I'm sorry. I should have listened to your side." "Water under the bridge," I said, literally. He laughed. We kept working. By the end of the day, my back was sore, my hands were covered in dirt, and I felt better than I had in months. Curtis Lehman wrote a follow-up article in July. Headline, "How One Retiree Turned a Property Fight into a Conservation Win." It got syndicated to 3 regional papers. I started getting emails from people all over the state dealing with similar disputes. I couldn't help all of them, but I answered every email, gave advice, shared templates, pointed them toward resources. Some of them won, some of them settled. A few lost, but at least they fought. That mattered. In September, I was invited to speak at the State Property Rights Association conference. I stood in front of 200 people and told them the same thing. I'll tell you now. Document everything. Know your boundaries. Use the law. And when you win, build something better than what you tore down. It's been a year and a half since I locked that chain across the access road. The community access agreement is working. 187 families used the lake last summer. 0 rule violations. The conservation fund secured a matching grant from the state, another $120,000, which we're using to build an accessible fishing pier for people with disabilities. Paulette's board is working with me to develop a trail system around the lake on properties whose owners actually consent this time. Brenda moved to a different development about 40 minutes away. I heard she joined an HOA board there. I don't wish her ill. I just hope she learned something. As for me, I'm still here. Still drinking coffee on my porch at sunrise. Still watching the water. Still grateful I stood my ground when it mattered. Here's what I learned, and I hope you take this with you. 1. Document everything. Document every conversation, every email, every incident. Paper trails win cases. 2. Know your property lines, get a survey, understand what you own. 3. The law protects you, but only if you're willing to use it. 4. Authority without accountability is just bullying. Make them accountable. And 5. When you win, don't just win for yourself. Build something that lasts. Build something that helps people. That's how you change the culture. If you're fighting an HOA, a bad boss, or any system that thinks power means more than law, know this: you're not alone. Share your story. Learn from others. And if this story helped you in any way, share it. Justice is contagious. Now go protect what's yours.